on Friday Probate Report. I'm Kirk Kaplan with Kresge Legal and Accounting. And today I want to talk to you about community property in Nevada in probate under NRS 123.250. Now, as everything happens in probate, there's always a legal effect and an income tax effect that has to be worried about. And little do many probate attorneys understand that concept. Today I was watching in probate court where a widow survived a marriage of 25 years, I believe it was, and the husband had purchased residential real property, or the house that they lived in, for several years. And when he died, the house was titled in his name only. A daughter of the husband, which was not of the surviving spouse, came in and said that she gets part of the property, the house. What the argument that happened today was revolving around NRS 123.250. What really is going on is the spouse, the husband that died, he died without a will. And when someone dies without a will, that means that they die intestate. And the Nevada law kicks in and they look to the succession statutes in order to determine who is to receive the property after someone dies. There's a supplement to the succession statutes, which is 123.250. And essentially what it says is this, that community property, the one half attributable to each spouse in Nevada, the one half that's attributable to the surviving spouse, that property is automatically removed from the probate estate because it's his or her separate property. For the other property that is subject to probate, if this was not a survivor spouse in a community property state, then the succession statute says that property would be distributed according to a certain rule. Children first, parents, siblings, etc. But since there's a surviving spouse and there's community property in this state, NRS 123.250 kicks in and says community property that is of the deceased spouse will be conveyed to the surviving spouse after death. Now, had the deceased spouse left a will, in other words, died testate, then this statute right here would not have applied. So this is one example of Nevada revised statute that saves, through public policy, the rights of the surviving spouse to receive property that was community with his or her spouse before his or her spouse died. The other aspect here is the tax implications. In community property in Nevada is one of the 8 states in the union where at the date of death of the surviving spouse, at the date of death of the deceased spouse, the surviving spouse can get an appraisal of that property and increase the value for tax purposes, or the basis for tax purposes, that new basis. So for example, if someone bought a house for $100,000 and at the death of the surviving spouse, or the death of the deceased spouse, I keep apologizing for that, the death of the deceased spouse is $250,000. Well, the surviving spouse at the death of the first spouse to die is no longer, the basis is no longer $100,000, but now $200,000, the fair market value at the date of death of the first spouse to die. So the next day, if the surviving spouse were to sell a house for $200,000, less $200,000 basis, that means zero gain. Had that step up in basis not been received, it would have been $200,000 sales price minus $100,000, giving you a $150,000 gain. Now, excluding the 121 exemption of $250,000 to each spouse, had that not been the residence, there would be a $150,000 gain subject to capital gains of 20%. You can do the math, it'd be about $30,000. I'm Kirk Kaplan with Kresge Legal and Accounting. I am happy to talk to you about probate matters.